Welcome to the Social Housing Retrofit Accelerator Masterclass in Contracting Options. My name's Andy Howarth and my colleague is Alice Allaby, and between us we'll present to you the contracting options for Retrofit Accelerator. First of all, we'll have a look at the preparation that we need to do for being ready to put in place the optimal contracting strategy. The first element of the contracting strategy really needs to be understanding the requirements and the outcomes that we're trying to achieve. Within the requirements, these could be quite simple products or materials, slightly more complex equipment requiring warranties and the like, works where we're leading people to go onto our sites and to provide materials and equipment, or the provision of services. All of these require different types of contracts, and we need to be alert to this when making our choices. Another key element is the scope, making sure we know exactly what it is that we're asking our suppliers to perform for us, and to what timescales and the budget. Flexibility is key in terms of understanding the amount of flexibility that we require in the way that we manage the suppliers. For instance, if we're looking for a high level of flexibility, and we may not be wanting to use a lump sum type contract. The other element to look at is the risks and the constraints and our appetite for risk, or whether we're looking to transfer the risk across to the supply chain. Another key aspect is the delivery model. We might be looking for a traditional construct only approach, a design and build approach. It might be a framework approach where we have an organisation that works with us regularly to perform these kind of works. We could be using a partnering model, sometimes known as alliancing, or construction management, where we look at individual packages and break works down. A more complex form of contracting might be PFI, which would otherwise require a rather different model because of the funding arrangements. Route to market is really important aspect of the early work, understanding where we're going to bring in our suppliers from. A popular route within public sector is to use the CCS frameworks, and there are other frameworks there that can be used, such as Procure 21, and these frameworks do provide an accelerated route to market. On the other hand, we might be looking to use FTS, which is the successor to what was known as the OJU public procurement route. Other options might be a sole source or other frameworks. There are a number of procurement procedures that we can select from. We've talked already about the options to use the OJU or the FTS route. And we need to be aware of the financial thresholds that are involved there, the different types of procurement that we might wish to use. And within there, we can be using open procedures, restricted procedures, a competitive dialogue model, competitive procedure with negotiation, innovation partnership. Alice will take us through the contracting options in a few moments, but beyond that, we mustn't forget the need to put in place robust and solid contract management. And that means having a contract management plan, putting in place the contract management tools, such as CMAR and other project controls. So I'll now hand over to Alice, who will take us through the contracting options.
Perfect, thanks Andy. If you could go on to the next slide, that'd be great. Thanks. So as Andy has already mentioned, there are various forms of standard form contracts that can be used, as well as more bespoke forms. For this presentation, we're going to focus on the JCT and the NEC suites, which are the two most suitable options. FIDIC, as Andy had on his other slide, is normally used for large international infrastructure projects. ICHEMI and that series of contracts usually used for process plants, and the PPC 2000 contracts being used for more complex projects where you might want a partnering approach and you would have a designer, a contractor and the client all working together. So the latter choice of contract really will depend on the delivery model chosen. In terms of bespoke forms, generally speaking, suppliers can be nervous of bespoke agreements, particularly, new developed agreements can require higher levels of scrutiny by lawyers, and this can potentially impact the supplier's appetite to bid for those works. But similarly, I would caution that heavily amended standard forms can also deter suppliers, so that is something to keep in mind. But generally speaking, the advantages to using standard forms are familiarity, depending on the extent of amendments, as we've said. It can be easier to price. They can reduce post-tender negotiations. There's an ease of administration that comes with that familiarity, and they usually come with a full suite of contractual documentation. So they have subcontracts that can be used as part of them, and the JCT will have example forms of bonds and guarantees that can be used as well. So looking at the first suite of contracts, that's the JCT, and some introductory points. As you can see there from the first bullet, JCT is the most frequently used contract. So around 80% of UK projects use this. I think currently it might be around slightly less, maybe 70%, but nonetheless it still is the most frequently used. It's drafted by a cross-section of industry bodies. So JCT stands for the Joint Contracts Tribunal. It has a full suite of contracts for all type of projects. So for example, it has the minor works, the intermediate, the standard, and the design and build, which we can look at on the next slide. But it also has major project forms, framework contracts, and management contracts. As you can see from the picture on your screen there, so the latest version of those JCT contracts is the 2016 edition. JCT, the next bullet down, so it has detailed drafting. It contains most of the elements that you may need for a construction project. It is tried and tested in numerous disputes, so owing to the frequency of use really. But it is seen as a more traditional or more adversarial contract, so it's not known as being a collaborative form of contract in comparison with the NEC. If you could move on to the next slide, please, Andy. So on this slide then, I've shortlisted the forms that may be most suitable within that JCT suite, although the most suitable form will link back to what Andy's discussed, specifically the delivery model. So this slide focuses on contracts for traditional and design and build delivery models, but you might need to consider other contracts. So for example, if there were requirements to incorporate, let's say, ongoing maintenance after the build of the works or the design and build, then a different contract may need to be considered here. As you can see, the JCT works contracts are actually aligned to the delivery routes. So you'll see that they're split into traditional and design and build. So the former, the traditional, being for situations where the contractor isn't carrying out any design, and this has already been done by the client, and the latter being where the contractor is required to both design and build the contract. They're then further broken down, the contracts, by complexity and value. So you'll see there for the traditional, you have the standard building contract, which is used for bigger, more complex projects. You have the intermediate building contract, which is for kind of mid-value, around 12 months, more simple than the complex ones. And then the most simplest kind of, or the form suitable for most simplest work would be the minor works, so for low value works and projects really. With the standard building contract, there is also two versions. So whilst the contracts share similar terms, the difference is really the way the contract price is determined and how the contractor is paid. So you'll see there one being a lump sum and the other being a remeasurement. And those kind of the breakdown in terms of complexity and value is also mirrored, you'll see there on the slide, for the design and build contracts. So for example, if you wanted a contractor, let's say, to install some insulation, it being quite simple and low value, you might opt for more of a minor works form. If you had something slightly more complex that involved perhaps the installation of insulation, perhaps some air source heat pumps, you might want to consider something like an intermediate form. And then if you're looking at something like, whole house retrofit solutions, you're probably going to want something like the standard building contract or the design and build, depending on whether design is required or not. But I would just say naturally, the guidance on the slides is just that. It's guidance and their rough parameters to help with that decision making process. But there's nothing to say that, if you're just because the works are maybe mid-value, if they weren't highly complex, there's nothing to say that you couldn't use a standard building contract or a D&B. So moving on then to the NEC suite of contracts, if we could move on to the next slide, please, Andy. Perfect. So NEC is the second most common choice of contract, but actually the first and foremost choice of contract for the UK government on major projects. It does have a balanced approach generally, but some key terms are often amended. It is, unlike the JCT, a one-size-fits-all delivery route, so it's not where the delivery model will be mirrored in the contracts. With NEC, it doesn't matter whether the contractor is expected to do any design or not. You would still use the ECC contract, which is the engineering and construction contract. So that would either be in the full form or the short form. NEC has a full suite of contracts. So again, like JCT, they have that framework, they have management forms, but NEC does also have alliancing forms of contracts for services, and they do actually, with their NEC 4 suite, they released a design, build and operate contract, which might be good to consider if you're looking for, maintenance requirements in that contract. You'll see from the next slide as well that actually NEC has a range of pricing options more than JCT. You'll see from the picture there, the latest version is the NEC 4 suite, which was published in 2017. It's a flexible contract, down to the fact that it is flexible in terms of delivery route and can be adapted. It's clear and simple, so it uses straightforward, non-legalistic language. There's several provisions in there which encourage good management, so updates of the programme regularly to reflect the progress of the work, monthly forecasting, and changes dealt with as and when it occurs. But that you can see from the next bullet down, it can be more resource intense. So I suppose that's the flip side of good management. So just as you have, the contractor submitting these monthly forecasts and programs, you've got to have someone on the client side who's accepting those, responding to that. NEC does promote more collaborative working. So as I said before, collaboration is a real cornerstone of NEC as opposed to JCT. Generally speaking, it does have a fairer risk allocation, although subject to those few, tweaks that we referenced earlier. And it encourages parties to resolve disputes outside court. So it has a tiered dispute resolution mechanism that begins with, senior party negotiations, or, with other steps in place prior to getting to that ultimate form of tribunal, which can be the courts or arbitration. So moving on to the next slide then, so which form of NEC contract? So as we noted earlier, NEC isn't aligned with those specific delivery routes. So whether you're looking for the contractor to undertake any design or not, the ECC contract would be the one that you use. And you can see there's a full form and there's also a short form. So the full form being used for more complex, potentially, higher value projects, and the other for more simpler projects that perhaps don't need as many sophisticated management techniques. In terms of pricing mechanisms, so the ECC is designed to have a bank of core clauses, and they're then supplemented by the particular commercial model that's chosen. So the NEC ECC has 6 main options in terms of the commercial model, but the most commonly used are the ones you can see there, which we've highlighted, that being the option A, which is the lump sum, the option C being the target cost. So the contractor is incentivized against a target, and then a percentage, is specified against that target in the event of underspend and overspend. And then you've got your option E, which is a cost reimbursable, where the contractor is paid their actual cost with a percentage applied. So those are for the ECC. You've then got, for the short form, note that there's only 2 commercial options with this, so that's either the lump sum or the actual measurement with quantities. And actually, the evaluation of the most suitable commercial model is an important part in any, contract strategy, and understanding what best meets the project needs, because actually which commercial model you choose can be influential and quite a determining factor in your choice of contract. So, for example, if you wanted to go with something like a target cost, you would have to think about a JCT, because that doesn't have that form, so you would have to create bespoke amendments and amend that JCT to allow for a target cost arrangement. Next slide, please, Andy. So once then you've considered your delivery model, your procurement routes, you've shortlisted your potential contracts that you might want to use, you can then undertake an assessment to basically see which contract best suits the client and your project needs. And when we're evaluating forms of contract, we often look at the types of factors listed on the slide. Naturally, these will need to be adapted for each client and project. We can then map out how those factors fare against the particular contracts. So this is an example of a type of tool that we use. As you can see here, we filled it out for NEC and JCT suites generally, but we'd recommend further breaking it down to analyse a particular contract. So if you're looking at a lump sum and you think, should I go for an NEC or a JCT, you might want to look at how they compare against your particular factors. Again, the choice of commercial model. So if you're thinking, do I go for an NEC option A versus a target cost, again, it's good to look at how they would compare, because they would model slightly different. So, for example, a target cost might be different to a lump sum in terms of budget predictability. I would also say consider giving the different factors weightings. So each factor might not hold equal importance to a client or project, and one might be, the overriding factor that might have to be taken into account. And indeed, one of those important factors that should potentially be weighted highly and that shouldn't be underestimated is client familiarity with a particular form. So consideration does need to be given, if it's something that you've not used before, to upskilling staff potentially, and the time and cost consequences of this. You might also want to look at how the contract aligns with internal governance processes and finance systems. And that will then feed into the client resources and administrative capacity, as it's one of the factors listed on the slide. So even if there is that appetite to upskill, is there the resources to administer a particular contract? As we've said before, NEC is more resource heavy than JCT generally. So it goes back to weighting those factors. Moving on to the final slide, please, Andy. So I just wanted to finish by reflecting on those key contract terms which really should be included in any construction contract. So once you've decided on a form of contract and you're looking at drafting it and putting it together, these things should really be considered. If you are using a standard form of contract, most of these things, if not all of them, will be included in the contract, or the contract will at least prompt you to consider these. But I know sometimes work is delivered under purchase orders or letters of intent, but really in order to protect yourselves and the contractor really, you should ensure that these key contract terms, you have a contract and these key contract terms are present. So the key things then, if I can quickly whiz through that list, is, so first and foremost then, a clear scope of works. So what is the contractor expected to deliver? What is he doing? And the more detail, the better. So for example, if the contractor is installing some solar panels on the roof, is there a specific specification that he has to deliver to? Does he have to provide operating manuals as part of the installation? Does he have to provide training or an explanation to the client or the tenants as part of this? So being as clear as possible is very important. Secondly then, an agreed programme and time frame for delivery. So you can see there, it's really important to agree, what is the starting date? What are the access dates, particularly in relation, to tenants and working in their houses? Are there any restrictions on that? When can the contractor have access? And then importantly, the completion date. So when is the contractor committing to have delivered everything that he needs to do? The next one, agreed price or an agreed pricing mechanism. So how is he being paid? Is he being paid, you know, in accordance with a lump sum? What's included in that fixed price or that lump sum if it is? And that will really link back to having that clear scope, so there's no arguments later down the line as to what is or is not included really in that lump sum. The next one, so ensuring that there are provisions for warranties and guarantees within the contract. So most standard form construction contracts will have options for warranties and guarantees. Subcontractor and subconsultant warranties being very important, particularly in the event that the contractor goes insolvent. So this means that the client would have a direct contractual relationship with that subcontractor or subconsultant who did the work. So if there's any issues or it's faulty, they have that direct recourse. And that's also important as well for making sure that the client gets any manufacturer's guarantees or warranties, again, in a situation where the contractor might be out of the picture for one reason or another, and you've got some faulty equipment on your hands, you can go straight back to the manufacturer. Next one then, clear insurance requirements. So what insurance is required? So what insurances does the contractor have to have? What is the level of cover that he has to have? And what is the basis of any claims? Is it in the aggregate or each and every? We would always recommend engaging with insurance advisors as early on in the process as possible, really, so they can advise on this. In terms of retrofit works, we find that one of the kind of key insurance requirements is to do with existing structures. So what happens in the event that, let's say, the contractor damages the roof installing some solar panels? So who insures that risk? Sometimes we find that local councils, you know, might have their own insurance policies which will deal with damage to their housing stocks. They either claim on their own policy or they can extend that to cover the contractor in a joint names capacity, or simply the case that the contractor has to obtain his own policy for existing structures. But again, engagement on this particular, you know, complex issue early is, I think, very important. The next one then, clear allocation of risk and liabilities. So it's particularly common now to have limits on the contractor's liability, but again, setting any limits needs to be carefully thought through and considered. They're often considered hand in hand with insurance requirements. So what are the level of insurance requirements, and then where is suitable to therefore cap that contractor's liability. The next one, tenant considerations. So usually with these retrofit projects, there's three parties involved. So you've got the client and the contractor who are in contract with each other, but then you've got the tenant who's actually living in the house where the works are taking place. So you need to make clear any requirements. So are there access requirements? You know, does the contractor need to provide the tenant with a certain number of days notice? How should he do this? Are there any restrictions on access? What about situations perhaps where the tenant is vulnerable? Are there any additional kind of processes and procedures that are required? So within our contract, we've seen a whole range of things. You know, we see clients sometimes adding in rules of conduct, which place kind of restrictions in relation to how loud the contractor can have music when working in properties. You know, the fact he can't swear, the fact he has to leave the house in a clean and tidy state. So all these things can be included. Or as discussed above, you know, are there any requirements in terms of engaging with the tenant in relation to how they use the equipment, you know, training them, providing them with manuals? So those tenant considerations are extremely important dynamic, I think, when you've got retrofit works. The final few then, change control processes. So if you need to vary the contract for a particular reason, whether it be the scope, the amount, you know, anything like that, how do you do that? How is the change dealt with? How is it quantified? How is it agreed and ultimately implemented? But how robust and detailed these change control processes will ultimately be dictated by how complex the project is. Termination rights, so what rights of termination exist? Often we see central and local governments or public bodies require rights to terminate at will, particularly for situations where funding might be withdrawn. So it's important, if this is something that's required, you know, ensuring that in your contract that you have a right to do this. And key to that is also, what are the cost consequences of exercising that right? So be prepared and knowing how much it would cost to exit that contract, and any additional procedures and processes that might take place upon termination. Dispute resolution procedures. So what dispute mechanisms are there? Is there a tiered system like NEC? Ideally, you want something that goes through, you know, processes, and, you know, under the Housing Grants and Regeneration Act, a construction contract, there is always the right to adjudicate. So there is that right, but introducing things like, you know, more informal, maybe senior party negotiations or something like that before you get to those more formalised dispute resolution mechanisms, and ultimately court and arbitration, because those can be extremely expensive. And then finally, considering forms of performance security for larger projects in particular. So that could be by way of parent company guarantees and performance bonds. But as I said, probably for larger projects, these might not be needed for more simpler, low value projects. So that's the end of our presentation. Thank you very much for listening.
Thank you.